that the entry of yours into the legal fraternity was challenging in relevance with the social background and all the things?
First of all, I will say that if you want to become a good lawyer and if you want to sustain in this legal fields, do not forget research. And if you feel that I do not have time for research, I would rather
In our Hindu tradition, woman is considered to be Narayani. With this thought taking into consideration, LawSplat has come up with a series of podcasts, and today amongst ourselves we have Dr. Debarati Halder, a research academician, an expert on cyber law, therapeutical jurisprudence and victimology. We welcome you, ma'am.
Thank you.
So ma'am, firstly, how do you feel being such an amazing and astonishing research person, having your journals and your publications in the Harvard Journal, and thereby after getting recognition on your publication from the UN and the US Department of Justice? So how does it feel from inside? And more importantly, ma'am, according to you being a research person, how important it is for a research for being a research scholar, or for if we ask from a law student's background, how much it is important for a law student for future reference as a legal practitioner and as a professor, the basis of research?
Okay, so when you want to go for legal education, or even when you want to become a lawyer, our basic understanding is research, because if you do not do research, you will not be successful in the court of law. However, somehow I really felt very comfortable with research because I enjoyed it. And once my first international article got published, this was in Law and Religion, and I wrote something on Hindu women's property right. This article went for review for around 1.5 years. I actually started feeling very depressed because I thought that it will not be my cup of tea. But one day I did get to see that it got published, and I was so very happy because my hard work for 1.5 years, my waiting period for 1.5 years, it was basically successful. After that, I started doing research, and during this course of research work, many editors especially, they have rejected my work. Many reviewers have given me very bad review, but somehow I really felt that I need to be in this field. And slowly when I started doing my research, I actually felt that I might be knowing more than what the judges will also know. And I was proved right when my research article, especially on, this was a very significant article for me. This was on Andaman Jarawa women's right. This happened in 2012 when human safari videos became very much prominent. I decided to do my research on this. I contacted the BBC journalist for research purpose, and I had a detailed research. This was published in British Society of Criminology Journal, that is BCJ, British Journal of Criminology, and I actually did this research, and then I actually felt that okay, this is published, so let me not go ahead with such kind of research. I will be indulging in some other kind of research. Many years after that research was published, one day when I was ego searching, I did find out that my name was showing in US Department of Justice portfolio. And when I opened it, I found that this was the research paper that had been taken, because this has become a very significant phenomena, that is using cyber tools to victimize women, especially indigenous women who may not know how to come over for reporting, and who might not be knowing that what is the consequence of the entire capturing of their videos. This basically encouraged me again to go for many more researches. So my last book that was published, it was cyber victimology. This was the first book in the world which is on cyber victimology. I have discussed about the entire concept of victimology as it should be taken from the perspective of cyber law, cyber crime and cyber crime victimization perspective. After that, I have written many other research articles, because as I stated that I feel very much close to the victims. I feel very much close to the why it is happening, that is cyber criminology and cyber victimology. And while I'm doing this, I have seen that there are many judgments that are coming up that are not expected or that are not accepted by the society at large. While I was doing my research on this also, I actually understood that because this is a very new phenomena, judges, especially the cyber law I'm talking about, judges may not have understood because many victims did not feel like reporting it. So therefore, actually the judges will be able to understand, give the meaningful judgment only when such kinds of patterns of criminalization or patterns of criminal activities are reported or acknowledged. That never has happened before. And while I'm doing this kind of research, I am getting connected with many other stakeholders, including academic societies, etc. And one of such society is Therapeutic Jurisprudence Society, International Society of Therapeutic Jurisprudence. I am the founding trust member for International Society of Therapeutic Jurisprudence, especially from India. There I did get to see that how the judges and the legal academicians and the lawyers, they have got a clear communication on a different platform about this is happening, why people are not happy with the judgments, and what to be done. And since it is a US based society, I did get to see that that's the entire this lacunae is being filled up by the students and by the faculties, researchers of law, which I really felt is lacking from India. And here again I have seen that many, I will not say many, some premier institutes in India, they are doing legal research, but somehow that is not actually reaching the masses. Say for example, when you are getting to see some criminal law jurisprudence related research, etc., it's only we the academicians, we are reading for the purpose of again writing something else. If I am telling to my LLM students, to my PhD students, they neither have the patience nor have the time to read all these things. So in this, I must mention about Professor G.S. Bajpai, who is presently the Vice Chancellor for NLU Delhi. In one of the meetings, he stated that if we do not bring this legal, academic mindset to something which you people are doing from LawSplat also, that allowing people to write as blogs, allowing people to come up and speak as such on such platforms, etc., nobody will be able to understand that why we do research, what is the significance of research, and what is the consequence of research. So I think this impacted, this influenced me to become a researcher, full-time researcher, and also faculty for law. And I think as a woman, this is very, very important, because if we women are not researching about crimes against women or any other civil rights, etc., no one else can do it. So that's the basic reason behind why I am a researcher and why I'm a passionate researcher.
Okay, so basically it's all about researching and having a quest of knowledge in the future.
Exactly.
So ma'am, when we look into the history of any of the field or developing of any of the field, we'll see that the fields were not so welcoming regarding the entry of women, and women had to struggle quite a lot to gain a position of power. So being a 20s era female legal personality, how do you feel? Was it struggling to enter into the law field or gain space, or how there were social challenges cropping around? So
okay, see, first of all, let me tell that I come from a family of bureaucrats, right? So somehow before I knew, my parents knew that I'm going to be a lawyer or a judge. So therefore, being a woman and then entering into the legal arena, it was not that challenging for me or for my family, because my father was an IPS officer, my mother was a professor, my sister, she's a banker right now. So we know that we women need to go for such kind of challenging jobs. And I grew up in an atmosphere, or rather I will say in an environment where I have seen Kiran Bedi, who is the first IPS officer, female IPS officer in India. I grew up in a society, like in a residential society, where I did see that the first woman IAS officer of West Bengal, Mrs. Ranu Ghosh, she used to be very strict administrator. We used to have, because she was our neighbor, and I was friend to her daughter also. So we used to see that how women administrators, how women judges, how women police officers, they behave. And after that, definitely I did get to see, when I was studying in my undergraduation course, I did get to see there are very good professors of law. So I was very much influenced by them, even though I did not have them as my direct professors, but whenever I used to go for conferences, etc., I did used to follow them. I did used to watch them. Slowly, when I entered into my profession, the challenge actually came at that time. Why? Because I was practicing. From Calcutta, I went to Tamil Nadu. I was practicing in Madras High Court, and the challenge came not from that I am a woman, etc., but the challenge came from the society that being from other state, many people actually thought that I won't be able to survive. And also, yes, then I did get to see about the women empowerment, challenge to women empowerment, because at that time I was the only female or a woman lawyer from West Bengal who came to Chennai or Madras at that time, who was practicing. But even there, when I joined Surana and Surana International Attorneys, I got my colleagues, my senior colleagues, and also my rather I will say my administration, which were headed by women. Say for example, Mrs. Leelavati Surana, she is the partner of Surana and Surana. So I used to see her, and she was an excellent mediator, arbitrator, and also a counselor. Other than that, I had my friends, most of whom were women, young women, and they were very good. But while I used to go to the courts, I did hear such kind of misogynist comments, etc., whereby I still remember some clients would be coming and telling to our sirs, Surana sir or Mr. Kalyan Jawab sir, etc., that ye to bachchi hai, and she is a very young child. I mean, she is a very young female. How can she go and represent us? But we did win cases. And after that, I started seeing that women started getting kind of trust in women lawyers. But again, while I, as a practicing advocate, I was passing through these years, I actually felt it is extremely challenging, because looking after the family, then thereafter looking after marriage, that is a new marriage, after that looking after children, etc., many women started taking that back step, that we cannot come over. After that, again, a new journey for me began, that I started right from the trial courts, etc., where it's again not my parents, etc., but again some families and some people, they started telling that it's better not to go for criminal law practicing, which I guess that every female law student
Definitely.
will be still getting to hear, that you have studied law, you are an excellent student for criminal law, etc., but do not practice criminal law. Why? Because it is understood that you are going to brush your shoulders with criminals, but it's not so. Because when you have studied law, you would be getting to see that clients are our responsibility. So it's our responsibility to make them feel comfortable by our services, and also if that person is your client, that is the defendant is your client, it is our responsibility to bring down his legal liabilities, that is the penal liabilities. So once the parents as well as the society and the families, extended families, they are comfortable that yes, my daughter, my sister, my wife, etc., can go ahead for these things, the journey becomes very smooth for us. Otherwise, it is a challenging journey. But again, I have seen many women, they have taken up judgeship, judiciary also, and after 1 or 2 years, they had to leave this. Again, this is the fear, I'm a judge, I'm sitting in the court of law, at the end of the day I have to go home, so I have to take care of my family, and because of this, because of my work profile, my family, my children might be harmed. So that is the reason people are leaving. But this is not happening with our male colleagues, right? So they, from the very beginning, they can go for the internship, they can go for practicing, etc., and that to very challenging field. So this is not happening. So I would rather say that even in 2023 also, there are several families, there are several societies which may not allow their girls to study law, because they may feel that this is something which is still now for the boys, for the men. And there are several families which will also not suggest that after finishing law you go for practicing, because I have seen many of my friends and also many of my students, many of my students come friends, they did not go for practicing because they felt that I have finished my law, now it is the time to start a family, and law is just a degree, it's not something for profession. I did my law, that is going to be a glorified degree. Unfortunately, I have also seen some of those friends and also youngsters who, after getting the legal degree, they had been violated, especially I'm talking about women, they had been violated, they had gone through domestic violence, and they have never opened their mouth because they felt that this is what I should live with. So I think that now the legal education awareness hopefully is widening, and from now onwards we want our girls to be more in the criminal law field. More defense lawyers are expected from the girls. Prosecution, definitely yes. I think yes, there are challenges, but I think now we are capable enough to address those challenges also.
Okay. So ma'am, currently we see that it's a very hotly debated topic regarding therapeutic jurisprudence being an emerging field of knowledge and research for the research scholars. So how it all began from when the term was coined in 1990s to the current view, how would you explain this term to a normal layman or even a newly budding legal person regarding the concept of therapeutic jurisprudence?
Okay. See, the point of therapeutic jurisprudence or the term of therapeutic jurisprudence is not something which was invented in 1980s. This was first used, the term therapeutic jurisprudence, rather I would say therapeutic justice, was first being used by none other than our Justice Krishna Iyer. And this was related to the prisons correctional administration. Why? Because in one of the cases from 1960s, Justice Krishna Iyer, he wanted the jails to be therapeutic, so that people do not enter into the jail thinking that I have committed a crime, now I am banished for my entire life, and therefore I will be blamed, I will be tagged as if I am an accused person or I am a convicted person. So what he said, actually he brought in the concept of Maharshi Valmiki, that if you have committed a mistake, you go through a systematic channel and it should be therapeutic. That means it should give you some kind of positive healing aspect, so that when you come out of the jail, you do not enter into that negative phase again, whereby you will be again committing crime, because this sits in your mind that I have paid the fine and max to max what will happen, I will again go to the jail for 3 years, I will again come back. So it is a kind of habit for me. This was the first idea that Justice Krishna Iyer actually mentioned from the Supreme Court of India perspective. After that, from 1980 onwards, professors from the US, especially Professor Bruce J. Winnick and Professor David Wexler, these two were law professors, they started developing the concept of therapeutic jurisprudence, not only from the victimological perspective, but also from the restorative justice perspective, as well as from criminology and penological perspective. After that, we do get to see that lot of cases basically they have handled from the perspective of therapeutic jurisprudence, especially giving a special emphasis on mental health, not only on mental health, but also on drug courts. Now in the US, what happens is that if there is any person who is mentally disabled, or for example who has become mentally challenged, etc., so obviously they will be committing nuisance if they loiter around in the streets or in the society. It's not like us that you do get to see mentally disabled persons, etc., on the streets, and people are throwing stones, etc., they are immediately arrested there, and they are taken to some kind of I would rather use the term confinement, etc.
Kind of rehabilitation centers.
No. That's the later stage. It's actually they are arrested, they are detained, so that their first activity is seen as if they are creating nuisance in the society. So if we consider it again from the criminal law perspective, if somebody is creating or committing nuisance, the immediate effect is that detain them, remove them from the society. That means detain them in the police lockup, custody, etc. But then these two professors, they started discussing about, if you detain or if you arrest mentally disabled persons, mentally challenged persons, you are keeping them in the jail. After that, somebody comes to sign some bond, or they take the bail, etc., the families will not take them back, right? Okay. So in such case, again they are coming back to the streets. Then comes, because this entire concept started from 1980s onwards, then came the question of rehabilitation, and then the drug court system, the mental health court system, etc., they came up long before we in India were discussing about this Mental Health Act. So they started discussing about applying therapeutic jurisprudence, so that any person who is mentally not stable, they are not undergoing, or they should not undergo some kind of prison sentences, or some kinds of criminal sentences, etc., but they should be seen from a therapeutic understanding. That means law is used as a healing tablet, a healing medicine. Now from this, law started therapeutic jurisprudence slowly started spreading its wing. So thereafter, we do have in our society, we do have judges who are looking after the domestic violence cases. They are applying these therapeutic jurisprudence cases. We have drug cases, drug court cases, who are basically looking after those youth, or those persons who are drug smuggling cases. They are actually coming in for drug smuggling cases, and it is also now being considered that consumption of drugs or drug peddling, etc., that also can be prevented, that also can be challenged if therapeutic jurisprudence coming up. After that, when I joined, I started expanding the wings again by applying therapeutic jurisprudence for cyber crimes. And my research suggests that yes, if we apply therapeutic jurisprudence for restitution of justice for cyber crime cases, especially for cyber victimization cases, victims may be benefited. So like this, therapeutic jurisprudence is still spreading wings. Presently, many are actually researching on sports and law, because about sports bully, physical sports bully. Yes. We also know about many other, say for example, very recently there was gun shooting cases. Yes. So this is also being addressed by the usage of therapeutic jurisprudence. And because we have got many judges in our society, so the judges are also directly communicating with the academicians, and they are trying to figure out that what sort of sentence will be therapeutic for the perpetrator as well as for the victims. For example, I can mention about a very good book which was really therapeutic for my own personal healing. This was titled as Bloodbath, and the author, he was at that time dean of law school, which was with Michigan University. So and he's also coming from indigenous background. So he actually started doing research as when there is ethnic clash or when there is community clash, how therapeutic jurisprudence, restorative justice, etc., can be used so that the victims and the perpetrators, they can be healed in different ways. And I really liked one thing, which I think that all law students must be taking it as a package. What he observed in his research was that the victims were trying to tell to the lawyers, especially to the defense lawyers also, we have reached the court, and our saturation point has now started beginning, right? So we are becoming satisfied that we wanted this person to come to the court, and we wanted to see that this person suffers. But right now, when the entire trial, sentencing, etc., is going on, we do understand it is not going to be finished so soon. So what we want right now, we just want the defendants, that is the perpetrators or the accused or the convicted person, to just have an eye-to-eye contact. and see that how I'm suffering, because in his research he showed that somebody is sitting without limbs, somebody is sitting without their family members because they have died, somebody has just come back from the hospital and mentally he or she is traumatized, etc. So the victims basically told that have an eye to eye contact and just feel that what I'm going through, and just say sorry. And if you say sorry, if you say I apologize, we will be forgiving you. If you do not say sorry, we will be keeping this in our mind and I will never forgive you. Even though the court forgives you, I will never forgive you. So thereby, what I am understanding, or what we are learning, is that the entire legal administration system is now become much more accessible and also much more appreciable by people from all across the world. Now, why it is happening? Because say for example, I am also getting to see in the US, in many other places, in Australia especially, Canada, and then in many other European countries also, therapeutic jurisprudence is giving a great lot of benefits to family violences, especially for divorce cases, and not only for divorce cases but also the children who are affected because of divorce. So this way therapeutic jurisprudence is also giving some kind of happening things. That means that it is actually being executed in a very nice way. So this is basically the journey of therapeutic jurisprudence, and I really wish that our students from India as well as from many other countries also, they should come, they should join the Society of Therapeutic Jurisprudence, and we should carry forward the ideologies that were created by Justice Krishna Iyer, or by Professor David Wexler, or Bruce J. Winnick, or even by other professors. And here I would also like to mention about one of my very favorite persons who were basically they came up as somebody who were victims of the entire situations. Later onwards, they became themselves lawyers, they became legal academicians, and they are also teachers of therapeutic jurisprudence. So obviously we should follow such examples, and we can carry forward the entire philosophy or understanding of TJ, therapeutic jurisprudence.
So ma'am, you mentioned that how it can be used as a capsule.
Yes.
So taking that into consideration, if we talk about if the accused is sent to jail, now thereby after he'll be having all the period in jail and having the rehabilitation process. So afterward, when he is released from jail, of course he'll find some hardships while
yes.
Adding into or joining the mainstream. So how therapeutic jurisprudence will curb the mental stress of the accused who is convicted while joining the mainstream society?
Okay, the answer of this can be found not only in therapeutic jurisprudence ideologies but also in the UN Declaration for the basic justice for victims of crime and abuse of power. Basically, this is a UN declaration which suggests, if you see the handbook also, which suggests for the restorative circles, or we call it as restorative clubs. Now what happens is that once the convicted person or an under trial prisoner, he enters into the entire correctional administrative system, we all know that they are given some vocational trainings. So it is accepted fact that when a person, especially who is a convicted person, comes out, or even an under trial person, he comes out after being cleaned or cleared of his criminal past, society may not accept them. Why?
Yeah.
Because that tag is there that yes, that the person will be again committing that particular criminal activity, and this is basically a tested fact that if you have tested the bad side of the water, you know how to use it again and again for your defense. Now comes, actually this is the reason that the society basically thinks that once a criminal is always a criminal, and that is to a certain extent in my head also, I also accept this, I also agree with this, because again I'm saying they know that again I will be paying fine, and that fine will go to maximum 1 million. I will be gathering the fund, I will be paying the fine, but then I will be again committing this because I need to survive. or I need to have a clean past, or I need to have some kind of food in my stomach, and because of this hunger, etc., that is the reason that if I do these kinds of things, I'll be getting food, etc. Now therapeutic jurisprudence basically suggests that especially for the accused persons also, go through the correctional administrative system, learn something new, and by that you can basically start coming out of that negativity. Here I would like to mention as my mentor, my guru, Lauren Walker. She had been chief attorney of Hawaii Island, and she's presently I think 78, 79. She's very active. She still goes for surfing in the seas, etc. And she suggested, she's also a yogini, so she suggested that if it is the speech, that is the communication, making the accused understand why, or the convicted understand that why it is wrong, and also making them diverted to something which is very, very much productive in otherwise, and also making that person empowered and enabled to earn a living. We think that the therapeutic jurisprudence aim and objectives may come be fulfilled. Why? Because that criminality may come down. Why? Say for example, she has given she actually is associated with another organization which is related to forgiveness. So here also comes the question, we know as law students, as lawyers, we know the role of effective communication.
Yes.
So what she and others, that is the gurus of therapeutic jurisprudence, they suggest that this effective communication should be something which is therapeutic. Now here comes the question, when that particular person, that is the convicted person or the accused person, he comes out to the society, that communication should be effective. That means you should build a trust in the mindset of the victim and the society, because we know if you are seeing it from victimology perspective, society, the state also becomes a victim. So if you start giving that kind of trust in the mindset of victim or the state, yes, I have committed a wrong, I have understood what I have committed, and I would like to help you out. I want to repay, or rather I will say repair the damage that I have committed, and that should be done by my positive service. That should be done by serving the community, by serving the family which is which is affected, etc. Their therapeutic jurisprudence will be winning. And she has also shown this, that say for example, drug abuse cases, those children or those young people who were addicted to drugs, etc., once they are introduced to yoga, once they are introduced to therapeutic circles, restorative circles, etc., or those, because if that those people who are addicted to drugs, etc., they will also commit some crimes.
Yes.
So once they are also pulled out from that negative circle to a positive circle, definitely you will be getting to see that they are actually yielding very good result. So I think this we have started in India also, and this is not something which is very new thing, because when Kiran Bedi started the jail system, correctional administrative system, some shadows of it can be seen there. But I think that now even in Gujarat also we do get to see in Sabarmati jail, that is the central jail, this correction of the mindset, this is also being introduced. I think this is the way that slowly this entire thing is now flowing in the proper channel. But again, we also do get to see, especially for civil criminalities, especially for example, because these are now being studied more and more, marriage related offences, then thereafter some kind of civil offences, say for example damaging to the property, but it is not that criminal damage, it is what we get to see kind of the voluntary non-fit injuria kind of things, or for example some tort kind of things. So in such cases maybe therapeutic jurisprudence may be used, and this kind of difference of mindset, that means that you are a criminal and I am the victim, this can be brought down.
So ma'am, one of such incident happened with me regarding the cyber fraudsters. Basically what happened is that one day I received a call. A person stated me that my father has given me him my number, and he has asked me to transfer X amount of money. Now basically I am aware about such prank calls, or even I can say cyber impersonification regarding fraud calls. So I was aware about the fact, and I didn't transfer the money. I first thought to recheck with my father. being from a legal field, I was aware how the common masses or the laymen will be aware about such fraud calls, and even if I would have transferred that money, I would have been a victim. So a state of mental pressure, or I can say mental upset, would be there in me regarding that my father's hard-earned money and I was just fraud by some other person. So how to consider such things regarding the cyber law in connection with the victimology?
Very good question. Okay. First thing is that, see, we lawyers or we law students, we are aware of certain incidences or certain, kind of criminal activities that may happen by impersonating somebody, and also with a intention to make some kind of fraudulent activities, etc. This may not be the situation for non-law students.
Exactly.
This may not be the situation for those who are not aware, even though they are educated but they are not aware. I have seen, keeping this in mind, that your question, I have seen even people of my age and who are teaching in universities, that means they're assistant or associate or professors, they have also been victims of cyber frauds. Now obviously when this thing happens, first of all we have to be very much even though in today's internet age we are very open, it is Vasudhaiva Kutumbakam, but when it comes to this kind of fraudulent activities, we must understand that it is only our close family members, that is parents, spouse, children. These three generations are closely associated with the family wealth. Therefore, if somebody says that your father has directed, or your spouse has directed, or your child is stuck up somewhere, we are not going to give away the wealth that has been accumulated by hard work, etc.
Yes.
And for this I would also suggest that if anybody comes to becomes a victim, that means that we are all aware about several monetary payment gates. So if something like that happens, and it is something again the communication is so convincing that you feel that yes, it is correct, do not go ahead for entire payment. At least pay a very small amount if that person is convinced that yes, it is happening. Because this is something which is again an example, when we are transferring money by UPI, I have seen people will be transferring 1 rupee, 10 rupee also, and they will ask that whether you have received this thing or not.
Yes.
Why we should not use this kind of tricks when such kind of imposting persons are doing it? Because when you are transferring the money, they would get to know that which bank account the money is coming to. But the moment somebody is transferring, even if it is 1 rupee also, that alarm rings in our mind that I have transferred, whether it is correct or not. So I would rather suggest that if that communication is so convincing, before giving away the money, you ask that person whose name has been taken by the fraudster, you ask that person and you be sure that this is not instructed by that person. And also, if you are not able to communicate with that person who is being pulled in, and you feel that no, something should be there, then you restrict yourself. If you cannot restrict yourself, do not go ahead for giving away everything. The moment you start communicating with this person, even if with 1 rupee also, it actually would be showing that some money has gone to that account, right? And you can take up, if you by that time also you get to understand that no, I am committing some mistake, immediately run to the police, nearby police, and you give entire data, details, etc. We all know that there are certain helpline numbers are there. Say for example, for such kinds of cyber fraudsters, etc., it is 1930. The number is there. So like that, we can basically give these details to the police. At the same time, we should also visit the nearest police station, because even if the police officer or the thana, that is the police station, they will be telling that no, this is a very paltry amount and we will not accept this case, but your complaint is registered. And many of us actually, even if we are not if that person is not a law student, and even if the person is a law student, we actually forget that if the police officer is not registering any complaint and we feel that we have been victimized, we can take that police officer to the higher authorities also, stating that this person has not registered my complaint, whereas it is a genuine case of criminal victimization. I think this should be kept in mind, and this entire realization should begin when a person is a law student. I believe, like LawSplat, like many other student organizations or student clubs, you people can be the ambassadors, to share such kinds of awareness to the society, and thereafter, if anybody needs any help, people like us, we are always there to help them out. But I think that again, going back to the basics, legal awareness is very, very necessary, and that awareness must be created by some persons who know particularly clearly about this. Again, I am saying that why such kind of awareness must be coming as we say from horse's mouth, because now I need to speak about fake news. You do get to see on WhatsApp so many awareness creating, quote unquote awareness creating, informations are given, but these awarenesses basically lead to malawareness or malpractices. So therefore it must be done by somebody who knows it, who has got training in this regard, and who can genuinely help the victims when they actually want to go to the court or the police.
Okay, so ma'am, as we move towards the end of our podcast episode, what is the advice that you would give to young lawyers regarding research, or any other tip that would be very fruitful regarding the awareness in the legal fraternity or our contribution as a legal person?
First of all, I will say that if you want to become a good lawyer, and if you want to sustain in this legal field, not only as a lawyer but also as a legal academician, as a judge, or anybody who are associated with the legal field, that means that if you are a corporate law practitioner or an advisor, company law practitioner, whatever it is, do not forget research. And if you feel that I do not have time for research, I would rather say that you have basically made assignments while you are a law student, you have written your dissertations while you are a law student.
Definitely.
You have also gone for law conferences while you are a law student. Just remember those things, bring them to your desk, and then start brushing them again and start publishing it. Because remember one thing, that the more you publish nowadays, I do understand that nowadays youngsters or even people like us also, we feel that if we create a reel or if we create any YouTube content, etc., people will remember us. No. The more you publish some study materials, say for example live law. When live law was started, even the judges also did not consider this as something which should be seen. But nowadays you are getting to see that even Supreme Court or High Courts or even outside jurisdiction courts are also mentioning about live law. Why? Because they are not only doing some kind of legal journalism, they are also giving platform for blog posting. Nowadays if you get published in live law, you feel that as if I have done a great thing, which is true, because this is being read by the judges. Now very recently I was invited by a judicial group of another country. I will not mention about that particular country because it is still under work. So they told me that they have read my papers. They told me that please contribute to our own journal that will be circulated among the judges, and these are not the trial court judges, but these are all High Court and Supreme Court judges, which basically made me understand that the more you publish, the judges are looking into what sort of ideas, ideologies and opinions you are following. And before we end this entire conversation, I would also say it is time now not to create a kind of impact in the minds of the clients only, but it is also in the minds of the court as a system, that I believe in this system, I believe in such kind of ideologies, and therefore my arguments, etc., are going in this positive direction. Otherwise what will happen is that when you will be standing before the court or before the judges will not pay attention to you. As a result, you might lose your case. As a result, your clients will lose trust in you. So therefore, the more you are writing, right, and the more people are identifying that yes, this is the person who has written about that, or this is the person who has shared the opinion about this, you will be getting to see, you will be getting automatic client flow. You will also be getting that confidence to stand in front of the judges, whatever tough judge it may be, whoever the judge is, even if it is a trial court judge to even if it is the Supreme Court full bench also, you will feel confident because believe me, it's not only my own opinion but also my friends and colleagues who are authors, writers, researchers and lawyers. They have all shared this common experience. If it is, say for example, cyber law, okay, and some kind of cyber crime incidents has happened, the judges have said, we don't know, you tell us that what is the situation, how would we go? Because whenever put yourself in the judge's chair, the judges will be seeing the fact of the case, the merits of the case and the technicalities of the case. If they do not understand that the facts and merits are to be analyzed, how can they think that they will be bringing some laws or technicalities to apply in them? Therefore, if you say that yes, I have researched, yes, I know, etc., the judges will also be convinced. So this is a kind of cycle. You have to be a researcher, you have to be a legal researcher. Not only that, you have to be a passionate researcher. Just don't go by the judgment orders, etc. I would rather say, just don't decorate your library with some fat books which you are not going to read. Rather, if you try to generate some more contents that you yourself has understood, and you yourself you are going to actually give it to the public that see, this is the law, this is what you have to deal with. And I think by that it will be the entire career, entire profession will be enjoyable to you. At the same time, the clients will also feel comfortable to come to you.
Okay. So ma'am, as we move towards the end of the podcast, and thank you so much for giving us your valuable time from the busy schedule and the insights that we had about therapeutical jurisprudence and victimology in we can say connection with the cyber law, and lastly the importance of research. I'm sure that we'll all be, and our viewers will surely be fueled with the passion of having research, going for conferences, and we can say rushing up with their final year and brushing their skills so that they can be a good lawyer in the upcoming market, which they'll soon join in few months or in the upcoming years. So thank you ma'am for being with us.
Thank you so much, and I wish all the best for all of you.
Thank you ma'am.